Yes. Lords, I've been through the facts and the chronology in Bullman, so I'm now going to come to the points that were argued. Now, if your Lordships have page 355, round about the middle, there's a sentence that begins, "a good deal of evidence." And your Lordships will see from that a case was run, this must have been by the owners, that the strike might have been, quote unquote, got over by using due diligence to get labourers from elsewhere. Well, that's talking about bringing in labourers to the canal once the vessel had arrived at the canal. And the jury found that that was not the case. Once the vessel was at the canal, the defendants could not, by due diligence, have improved the situation. So that argument was run, it failed. What's interesting about it, of course, is that it was run, because the implication behind it is that it was incumbent upon the charterers to exercise due diligence to get over the strike, even though there's not an express reasonable endeavours proviso in the exceptions clause, as it's quoted in the Law Journal case. And one of the points which Lord Justice Mayles makes about Bullman, he says, well, there's no equivalent of clause 36.3d. But in my submission, that's a false point once one recognises that an equivalent of 36.3d will be readily implied. And there's an argument here which is clearly based upon an implied reasonable endeavours requirement. And Baron Pollock doesn't say, well, no, as a matter of law, that there was no such obligation. It goes to the jury, and the jury says it doesn't stand up on the facts. And we'll see when we come to the Court of Appeal. In the Court of Appeal, there's a very explicit recognition that there is an implied reasonable endeavours proviso, even though it's not made express. So that line of argument fails. That leads Baron Pollock to conclude about three-quarters of the way down the main paragraph that the questions are whether the defendants were within their rights in ordering the vessel to the canal, and then she having gone there, whether they were not protected by the strike clause. At the bottom of 355 over to 356, he goes through the facts. We've already gone through that. The second substantive paragraph in 356, he has doubts about whether the defendants had acted reasonably in ordering the ship to canal when there was a strike which existed to the defendant's knowledge before the vessel arrived. It's a slightly strangulated question, bearing in mind that when the order to go to the canal was given, before the ship left the Tyne, there wasn't a strike, because the strike came later. But he puts the question to the jury, did the defendants act reasonably in ordering the ship to the canal? And perhaps not surprisingly, the answer that comes back is yes, by reference to the order that was given before the ship left the Tyne, because there wasn't a strike. But then he gets a bit more to grips with the real issue, because it's further suggested, and this again must be by the owners, that the charterers should, when they heard about the strike, when the ship was in transit, intercepted it and ordered her to some other place named in the charter party where there wasn't a strike. So he asks the jury a second and rather more focused question, whether it was reasonable to allow the vessel to continue the case after the defendants knew about the strike. And the answer to that is more favourable to the owners, because the answer is no. And it is further found that if the vessel had been intercepted and had been redirected, it could have been discharged within the period allowed by the charter party. But in circumstances where it was allowed to proceed to Regent's Canal, it couldn't be discharged within the time. And therefore, that must refer back to the jury's answer to the second question. That raises the question very clearly and neatly whether it was in the right of the defendants to order the Ashdene to the canal and to leave that order undisturbed, although before she got there the strike had commenced. Now, on the facts, it's that latter part that's the key. The order is unobjectionable. There's no strike when the order is given, and the strike was very sudden and unexpected. The issue here is the one raised by the answer to the second question. Should they have redirected the ship when they learned about the strike? And if they had done, it would have been discharged within the lay days. Now, 2 points to make, just pausing there. Lord Justice Mayles makes a slightly Delphic comment where he says that, well, there's nothing to tell what criteria the jury applied in assessing reasonableness It may, he said, be because they thought it would be reasonable to share the pain caused by the strike, in which case the decision finding had nothing to do with whether the strike or its consequences could have been overcome by diverting the ship. That's paragraph 61. It's not a very clear comment, but it just doesn't fit with the context. For one thing, the jury don't only find that it would have been a reasonable thing to divert the ship. They find that if it had been diverted, it would have been discharged in time. And that surely indicates that the criteria was, should they have diverted the ship because they could have discharged the vessel in time. And that was the whole debate in this case as to whether something which could have been done by the charterers to allow the vessel to be discharged in time. Well, again, remembers the argument at 355, they could have brought in substitute labourers. It went to the same point. Could they, by bringing in substitute labourers, have discharged the vessel within the lay days? So that was the point. And the finding was that if they had redirected the vessel, it wouldn't have been a question of sharing the pain, because the vessel would have been discharged within the lay days, the delay would have been avoided. So that, I submit, is an incorrect observation by Lord Justice Mayles. The second point is there seems to be a bit of a suggestion in RTI's case that this second question and the jury's answer to it really didn't feature in the analysis, the judicial analysis of the question of law. But one can see that that is not right, because at the bottom of 356 it is that, i.e. the answer to the second question, which raises the question very clearly. And the whole question is whether it was permissible to leave the order undisturbed. It all goes to whether or not the vessel should have been redirected. So the jury's second answer isn't incidental, it's critical. It frames the critical question. Back at 357, the factual observation is made there that the reason why the charterers chose the Regent's Canal out of all the options under the Charter Party was that they were delivering to a gas company, and the gas company required the coal near to the Regent's Canal. So it was a matter of importance to them that the ship should go to the canal. Pausing there, Lord Justice Mayles suggested at paragraph 71 that that was an important finding, and it is something which distinguishes Bullman from our case, and the implication is that this shows that there would have been detriment in Bullman if the vessel had been redirected, by contrast with Lord Justice Mayles' conclusion that there would have been no detriment in our case if we had accepted Euros. The problem with that analysis is that one will see in a moment that it's not an important finding at all. Baron Pollock expressly says that it doesn't matter in the slightest.
Yeah.
He then says around the middle of 357 there's a comment that the strike was very sudden and unexpected, which we've already looked at. There's a hint in RTI's case that suggests that Baron Pollock had doubts about the jury's answer to the question of fact. That's paragraph 73. That, I would submit, is reading far too much into a really innocuous comment. It
wouldn't matter, would it?
It wouldn't matter, because it'd be bound by it. Exactly at one point that Mr. Justice Jacobs made, I mean, just as we all are bound by the findings of the arbitrators in this case. It wouldn't matter. But in any event, he does say that it may be, because the strike was so sudden, it may be if they shifted the vessel, a strike would have broken out somewhere else. But he then says very clearly, it's immaterial. All of this is immaterial, because in Baron Pollock's view, it turns on the real rights of the parties under the Charter Party and not on the question of whether it was reasonable or unreasonable to send the vessel to the Regent's Canal. And in the very next sentence, he says that what Lord Justice Mayles calls the important finding about the gas company, that's immaterial too. It had nothing to do with, the contract had nothing to do with and could not be affected by any contract with the defendant had made with third parties. It's easy to see why she was wanted having a cargo of coal on board to be near the gas company's works, but that could not be set up as against the plaintiff's rights. So this point that Lord Justice Mayo suggests is an important finding. It's not important to Baron Pollock. It bears no influence on his reasoning at all. Because, as he says again towards the bottom of 357, so far as he is concerned, the question is, what was the contract between the parties?
Yeah.
It's all about the rights and obligations under this charter party. Contracts with the gas company don't go into it. And the conclusion to which he has come is that the option is for the defendant's benefits, and they have a right to act on it. And what he must mean in the context by act on it is they were entitled to maintain the order once the strike started, and they learned of it. They were not obliged to redirect. Even though it turned out that when the vessel arrived at the port there was a strike, the plaintiffs are not entitled to say that the defendants, because there was a strike, they ought not to have allowed the vessel to go there, because it was not reasonable to go there. So notwithstanding the jury's second answer, it wasn't reasonable to allow the vessel to continue after the strike broke out.
So this is a business option?
It's a business option. That, Your Lordship is right. And it's not a question between the plaintiffs and the defendants as to what's reasonable or unreasonable. It's a question of contract between the parties. And therefore his conclusion on 359, the last 3 or 4 lines, the defendants were in their rights in sending the vessel to that port. Again, in context, that must include persisting in the order after the strike broke out. And notwithstanding the finding of the jury on the question left to them, there ought to be judgment for the defendants. And the finding of the jury must, in context, be the finding on the second question, the finding that it was unreasonable to allow the vessel to continue to the canal. So that is the decision, and what the significance of it is I submit, is this. The focus was entirely upon contractual rights. And once Baron Pollock had decided that there was a contractual right to maintain the order, that was it. That was the end of the case. He was not concerned with any second stage inquiry as to whether there might separately, under an implied reasonable endeavours proviso, be a requirement to give up that contractual right if it was reasonable to do so. Notwithstanding a clear finding by the jury when the question was put to them that it wasn't reasonable to maintain the order when the strike broke out, and notwithstanding the fact that arguments about reasonable endeavours to get over the strike were in play. And the first argument put on page 355 is you can get over the strike by bringing in labour. Now that didn't work, but it shows that reasonable endeavours arguments were in play. Now, what is said by RTI is, well, Baron Pollock just doesn't expressly consider whether there might be a second stage inquiry under reasonable endeavours clause, although it somehow just didn't pass through anybody's mind. And it's true, it's not expressly articulated. But I would submit that that really proves too much for RTI, because what it indicates is that it simply was taken as read that once the contractual right had been established, that was the end of the case. There was no room for a reasonableness inquiry. It wasn't a question of reasonableness. It didn't occur to anybody in the case that it was necessary to articulate that point. It didn't occur to anybody in the case that there might be an argument that you could have a contractual right to send the ship there, but you might have to sacrifice it in the interests of reasonableness if you could get over the strike by reasonable endeavours.
Mr. Eaton, I think I ought, in fairness, to point out to you that within 5 minutes you'll be eating into your reply time.
I am conscious of the time, my lord, because I want to show your lordship the cases, I suspect that I'm going to eat into my reply, but thank you very much.
Yes, well,
or to reminder. So I may have a short reply, and that will no doubt be a relief to all of your lordships.
I'm perfectly relaxed how you used your time, but I feel obliged to point out that's where we are now.
Well, my lord, I would not claim that I am perfectly relaxed, but I am conscious of the issue. Now, my lord, that's Baron Pollock. Now, the law report in the official reports for the Court of Appeal is tremendously short. It's at page 360. And the question, Lord Esher says, is whether the defendants did anything more than they were by the terms of the charge party entitled to do. Again, note the focus. It's on the contractual right under the contract. He then concludes that there is nothing from which any limitation can be implied as to choice of the place to which the ship should go, unless perhaps there is an implied limitation in case something arises which makes the Regent's Canal one to which a ship of this kind cannot go. Now, that supposing one arises, that, I would suggest, is looking at some supervening event. And that fits the facts where the order is given, and then there's the supervening event because the strike breaks out after the order is given. So again, the question is in play. Did the supervening event require a redirection, a change of order? And the answer Lord Esher gives is no. At the time when the charters ordered the ship to the canal, there could be no objection. Certainly not. There was no strike. And there was nothing which happened afterwards to oblige the charterers to alter their order. So the supervening event did not require them to alter their order. The fact that they knew that the strike had broken out.
That's all he says about that aspect of the case, isn't it? That sentence. About
That's all that's said about supervening events. And that's in the context, my lord, of the jury's finding in answer to the second question at the trial that it was unreasonable not to redirect. The reasonable thing to do would have been to redirect. But notwithstanding that, nothing happened which required them to redirect. The outbreak of the strike, the fact that the vessel could have been discharged in time if it had been redirected, that did not make it incumbent upon the charterers to do anything to change the order. And that is notwithstanding the express recognition in the Court of Appeal of a reasonable endeavours requirement, which comes in the next few lines. There's the reference to the fact there was a strike. And then there's this. The strike would in itself not be sufficient to exonerate the charterers from doing the best they could to accept the delivery, and would not entitle them to fold their arms and do nothing. If, notwithstanding the strike, they could by reasonable exertion have taken delivery of the cargo in the proper time, the strike would not have afforded them any defence. But the jury have found that they could not by any reasonable effort have taken delivery. The delay was caused entirely by the strike. Now, the jury have found that they could not by reasonable effort have taken delivery. I think in context must refer back to the jury finding that bringing in labourers from elsewhere wasn't going to cure the problem once the vessel was at the canal. But nevertheless, that is an express recognition of what's implicit in the argument at first instance, that you can't sit on your hands in response to a strike. There is an onus to exercise reasonable exertion, which I submit is in no way different from reasonable endeavours which we've got here. It's implicit if it's not explicit.
But it's not suggested that it's relevant to whether they had to alter their order.
Or the other way round. It's not suggested that the jury's finding is relevant to whether they had to exercise reasonable endeavours by redirecting. There's not a tie-up between the two at all. And, of course, my learned friend will say that to your lordships, and they'll say, well, they just didn't put two and two together. There's a mismatch somehow. But again, in my
maybe that it was recognised it couldn't possibly be an answer.
It couldn't possibly be an answer. That, in my submission, is the more realistic interpretation. When you've got the arguments being put about reasonable endeavours, you've got a jury finding that it would have been reasonable to redirect. You've got a recognition in the Court of Appeal that there was an obligation to exercise reasonable endeavours. And then you get the decision that nevertheless they weren't required to redirect. The only reasonable inference is that it was obvious to everybody that reasonable endeavours didn't require you to redirect, once it had been decided that you were entitled to maintain the order. So it's all of a piece with Baron Pollock. The focus is on the contractual right and obligation. And once it's been decided that your order is valid under the port nomination clause, there's no get out for the owners by saying, oh, but nevertheless, on the facts, it would have been reasonable for you to change the order, and you are subject to an obligation to exercise reasonable endeavours.
Yes, once the contract option has been exercised, that is the contractual term.
That is the contractual term. Now,
And however reasonable it would be to do something else, you are entitled to stand on your contract.
a point that my learned friends make about that is, well, once you've exercised a contractual option, that becomes a contract, and they say, and you don't have the right to change it. And if you don't have a right to change it, then how could you be expected to change it in the exercise of reasonable endeavours? Again, I'd suggest that proves too much. It's right that in principle, once it's written into the contract, that becomes a contract, and you're not allowed to change it. But if the court had thought that it was nevertheless incumbent upon the charterers to change the order, assumed reasonable endeavours, then the court would have had to recognise, and would have recognised, an exception to the general rule that you can't change the nomination once it's made. But there's no thought given to recognising any exception, because there's no thought given to the possibility that it might be incumbent upon you to change the order, because it's just seen as clear and obvious in my submission that it's a question of contract, not of reasonableness. And if your order is valid, then you're not required to change it.
MUR had no right to demand payment in euros when they contracted for payment in dollars. The question is, were they required to change the contract term and accept payment in euros?
And we say not, because RTI had no right to pay in dollars. We had a right to be paid in dollars.
Mm-hmm.
And we were entitled, if that was our right, to say that that's our right and we're not required to change it. And just as in Bullman, the jury decision about reasonableness of redirecting the ship is treated as irrelevant in the context of reasonable endeavour, so we submit that the decision by the tribunal in this case that it would have been reasonable for us to accept euros and is likewise irrelevant. It's a finding of fact. It's not open to challenge, but as a matter of law, it's just irrelevant, just like the jury finding in Bullman. Now, there are some differences in the Court of Appeal report in the Law Journal report, which begins, the Law Journal report begins at 361 and the Court of Appeal is reported at 365. The main difference is, I think, if you look at the right-hand column of 365, my lords, what is expressed quite concisely in the official report as matters arising is more explicitly spelled out as being a reference to supervening events, something happening subsequently. For example, a war, or what had happened subsequently in this case was that there had been a strike, and it would have been reasonable to redirect the ship in the place of the strike, but that was said to be irrelevant. In the present case, there was nothing to prevent the ship going to the canal. And then about a little over 2/3 of the way down that right-hand column, the express recognition of the requirement to exercise reasonable endeavours is put more clearly in terms of the significance being causation. If by any reasonable means they could have taken delivery, then delivery could not be said to have been prevented by the strike. And I submit that that's a recognition that reasonable endeavours provisos, whether express or implied, are concerned with causation. And that recognition, I would submit, is quite correct. And then it said the answer to the plaintiff's case is obvious. The discharge was prevented by the strike on the facts. Again, looking at it in causation terms. That's a very short case. Vancouver Strikes case is very long.
I think you better take us to the key points.
I will deal with it very quickly because, for this reason, there is not, and there really cannot be any doubt about what it decides.
Yes.
The question is what conclusions, if any, do you draw from it from this case? Vancouver Strikes is the classic example of the contract option or Lord Devlin's business option. The contract there was wheat, charterer's option to load flour or barley. It's a voyage charter like Bullman and Fenwick. There's a specified number of lay days like Bullman and Fenwick. There's a strikes exception. It's described as an exception clause, but as I said earlier to my Lord Burrows, one of the exceptions is force majeure, so query, is it a force majeure clause or an exception clause? Does it matter? There is no express reasonable endeavours proviso. There is an express reasonable control proviso. It's a bit like the contract here. And the owners suing for demurrage said it's all covered by Brightman and Bungie and Bourne. That is to say, it's a performance option. And if you can't load flour because of the strike, then you have to load wheat or barley instead. And the decision in the House of Lords is no, it's a business option. It's a contract option. It's a contract to load wheat. The charterers have the option to load barley or flour instead if they want, but if they don't exercise that option, it's an option for them, and if they don't exercise it, then it remains a wheat contract. And if it's a wheat contract and you can't load wheat because of a strike, you can rely upon the exceptions clause, and it's not incumbent upon you to exercise your option to load barley or flour instead, because the option is there entirely for your benefit. Similar words to Baron Pollock in Bullman and Fenwick in describing a business or contract option. That's the decision, which on a narrow view is just a decision on the construction of the particular cargo clause in the case. The significance of it in my submission, and Mr. Justice Jacobs and Lord Justice Arnold accepted this, is that the analysis is all of a piece with Bullman and Fenwick in this sense. Once the House of Lords had decided that it was a business option, a contract option, that was the end of the case. There was no second stage analysis of, okay, we've decided what the contractual position is, but we need to explore whether on the facts it would have been reasonable for you to give up that right or vary performance in the exercise of reasonable endeavours. There's no shred of a suggestion that that was regarded by their lordships as a relevant inquiry. There's no hint of it in this. Now again, I think my learned friend would say, well, again, it wasn't put. Nobody thought of it. But we will submit, as Mr. Justice Jacobs said, that it's not a realistic interpretation of a case which was argued for 24 days in front of Mr. Justice McNair, and that genuinely was argument. It wasn't a jury trial, it wasn't a fact trial in front of Mr. Justice McNair. The evidence was all taken on commission in Canada. There were 24 days of argument in front of Mr. Justice McNair. There were 16 days of argument in front of the Court of Appeal. There were 9 days of argument in that House of Lords. Yeah, every in and out must have been considered by these amazingly clever people. And the realistic interpretation is the one that my Lord Hamden said a few minutes ago. It just, nobody thought that this was a get-out for the owners if they were wrong about what the contractual rights and obligations under the contract were.
So you say, as I understand it, that our case is almost a fortiori, so let's assume that in our case there were options presented. The option presented might be said to be that the ship owners can take payment at their option in euros rather than dollars, let's just assume that, you would say even if that were the case, that would be a business option, then on all fours with this case, and still it doesn't matter. You're not under a reasonable endeavours clause bound to exercise the option to accept in euros.
I would say that, my lord. You've always got an option in a broad sense to vary the contract or the performance or waive performance if you want. But what is one of the things, obviously, which distinguishes this case from Bullman and indeed from Vancouver strikes is there's no reference within the contract to different modes of performance. In Bullman, you've got your 5 or 6 low ports, and in Vancouver strikes, you've got your opposite in different performance. Here, it's not a contractual option, it's just a broad, you've always got an option to do. And in that sense, it is a fortiori. We're not obliged to do it. It's a question of right. It's not a question of reasonableness. That's what Baron Pollock says. And although it's not expressly articulated, the approach or reasoning in Vancouver strikes is all to the same point. Once you've identified the answer to the question of right under the contract, that's it. That answers the question. And I submit it answers the question here. And just as the jury's answer was irrelevant in Bullman, so the tribunal's finding here about reasonableness, it's just legally irrelevant. So my lords, I apologise for taking what is a very long case very briefly, but I do submit to say the question of what you take from it, what it decides is clear. I believe that was all I was going to say for the moment, my lords.
Thank you very much.
At some stage, but it may be that you want to deal with this in reply, I'd be interested to know what you say about BNS contracts against Victor Green, but maybe this is not the point at which you want to deal with that.
BNS contracts and Victor Green, the answer is, as Mr. Justice Jacob said, it was not non-contractual performance in any meaningful sense. Payment in dollars, forgive me, payment in euros would have been non-contractual in the sense that we'd have been entitled to reject it. And indeed, we'd have been entitled to reject it and say you're in breach because you've not made a proper timely payment. BNS contractors and Victor Green, there's an obligation to pay £9,000 for the work done, and what is non-contractual about it is that the hirers, the employers, say, well, we'll pay £4,500 by way of advance. Now, it's non-contractual in the sense that they weren't obliged to do that. And it's non-contractual in the sense that the employees weren't contractually obliged to accept it. But there's no question of anybody being in breach of contracts in the employer saying, in order to get you out of a pickle, we'll give you £4,500 ahead of time. And that's what Mr. Justice Jacob said about it. And in my submission, you were right. And your lordship will see Lord Justice Mayles didn't even see any need to grapple with that. He just didn't see any assistance to be got out of that case, for RTI at all. And in my submission, rightly not.
Well, thank you.
Thank you very much, Mr. Eaton. Just for your own planning, you've used 15 minutes of your reply time.
Thank you very much, Lord. I'm grateful.
Thank you very much. Yes, Sir Battert.
My Lords, may it please the Court. On behalf of the respondents, RTI, I would like to start by handing up a hard copy of the text of Clause 36 so that you have it beside your desk when I make my submissions on construction. I hope that's helpful. I have passed to the clerk a spare sheet if you wanted to use that. My learned friend knows that I'm handing this up, and it's been agreed that I can hand it up at the start of my submissions. Thank you. My Lords, while that's being distributed, Could I start by making a number of introductory remarks? My first point is that this case is all about the true construction of the force majeure clause in clause 36 of the contract of affreightment and the meaning of reasonable endeavours to overcome in clause 36.3d, which, as we've seen, was itself a specially negotiated provision introduced into the recap. Now, that provides that a force majeure event, which is defined as an event or state of affairs, which meets all of the criteria in A, B, and C, cannot be overcome by reasonable endeavours from the party affected. All members of the Court of Appeal treated the issue as being one of the proper interpretation of clause 36.3d in the context of the force majeure clause in this particular case. And for your note, this is Lord Justice Males at paragraph 47, Lord Justice Newey at paragraph 78, and Lord Justice Arnold at paragraph 71.
But do you dispute that a provision such as 36.3d would be implicit in most force majeure clauses?
Our position in relation to that is that one may have a position whereby a non-specified reasonable endeavours provision can require a party who seeks to invoke force majeure to prove that his inaction is not the effective cause of the effect on performance. But we do say that the authorities are very clear that you cannot rationalise conclusions from cases that concern different wordings in different contexts and then derive a conclusion which you transplant to the facts of a given case. It will always be a question of looking at the particular words of the clause that you are concerned with. Just to take an example, my learned friend has taken issue with the approach taken by the majority of the Court of Appeal that focused very much upon the text of the words, their context and their business purpose. However, Lord Justice Arnold did exactly the same thing, and his differentiation with the other members of the court was that he gave a very specific meaning to the word of overcome. He thought to overcome a force majeure event or its effects was not the same as solving the difficulty caused by the force majeure event or its effects. Now, if you're dealing with a case that doesn't even have an express reasonable endeavours provision, let alone one referring to overcome, it's very difficult to read Lord Justice Arnold's approach as providing any support to MUR's approach in this court. Now, I've mentioned that all members of the Court of Appeal treated the issue as being one of proper interpretation of clause 36.3d. They were also unanimous in considering that the authorities of Bullman and Vancouver strikes, which MUR had heavily relied upon in argument before Mr. Justice Jacobs and in the Court of Appeal, were plainly distinguishable. Lord Justice Males says this in paragraph 61 and 62, Lord Justice Newey in paragraphs 77 and 78, and Lord Justice Arnold in paragraph 75. The second main point I want to make by way of introduction is that there was no reason why performance of this contract could not lawfully have continued as a matter of US sanctions law. On the findings that had been made by the experienced LMAA tribunal in this case, that you will have seen comprised Mr. Jeremy Russell KC, Mr. Mark Hampshire, and Miss Sarah Kay, it was neither unlawful for MUR to load and discharge cargoes, nor was it unlawful to pay freight in dollars. Those findings are recorded by Lord Justice Males in paragraphs 17 and 20, and also appear in the Statement of Facts at paragraphs 25 and 26. Now, those findings were directly contrary to what had been asserted by MUR in its force majeure notice, which we looked at earlier, and which is in paragraph 18 of the Statement of Facts, reproduced in Lord Justice Males' judgment at paragraph 8. It having been MUR's case as set out in that notice, that it would be a breach of sanctions for owners to continue with performance of the contracts, and that sanctions would prevent payments in dollars. My third point is this: on a fair reading of the award, the force majeure event or state of affairs which the tribunal considered satisfied the criteria in 36.3a, b and c was the possibility of a temporary delay in transmission of US dollars to MUR through US banking channels, that being based upon the agreed position of the US law experts as set out in the award at paragraph 45 that you looked at before, and that this constituted a restriction on monetary transfers within the meaning of 36.3c, and/or any rules or regulations of governments or any interference or acts or directions of governments, referring to sanctions on Rusal within 36.3c. But that was always subject to consideration of whether MUR could bring itself within 36.3d. And there is just one point that I'd like to draw your attention to. When my learned friend Mr. Eaton showed you the reasons of the tribunal, he showed you paragraph 43, which referred to MUR's entitlement to take time to review the position and opt for caution. That paragraph was clarified and corrected by the tribunal, and you can see that at page 262 of the core bundle, such that paragraph 43 should in fact read in the last sentence, consequently, MUR were prima facie perfectly entitled, subject to consideration of whether the force majeure event could be overcome by reasonable endeavours to take time to review the position, etc. The inquiry which the tribunal accordingly had to embark upon and did embark upon was whether the possibility of a temporary delay in transmitting US dollars to MUR was a state of affairs that could not be overcome by reasonable endeavours from MUR as the party affected. My fourth point is this: the tribunal found as a fact that any temporary delay in receiving payment in dollars could have been overcome with no disadvantage and no detriment to MUR by RTI transmitting euros to MUR's bank in the Netherlands. This was MUR's designated bank under the contract of affreightment. You may wish to have a look at that, my lords. It's designated at page 276 of the contract in your core bundle, where the banking details for the freight payment are set out. ABN AMRO in Amsterdam, the Netherlands. Beneficiary, MUR Shipping BV, MUR being a Dutch company. So continuing with my point, they found that that temporary delay could have been overcome with no disadvantage and no detriment to MUR by transmitting euros to MUR's bank in the Netherlands which would then be converted into US dollars, to use their phrasing, as soon as the euros were received, with RTI bearing any additional costs and exchange rate losses in converting euros to US dollars, as RTI had previously agreed. Now, that's their clear finding in paragraph 50 of the award and is reproduced at paragraph 35 of the Statement of Facts. Now, based on those factual findings, the tribunal was unanimous in concluding on the facts, see paragraph 51 of the award, that the force majeure event could be overcome by reasonable endeavours from the party affected. Now, the majority of the Court of Appeal agreed, observing that on the facts as found by the arbitrators, quote, there was no difference between what MUR would obtain from acceptance of RTI's proposal and what it was entitled to under the contract. In other words, it provided MUR with the right quantity of dollars in its bank account specified in the contract at the right time, with no delays and with no detriment and no prejudice to MUR whatsoever.
That's because there'd been an assurance that additional costs or losses would be...
Exactly. And it's that proposal which was later accepted by MUR in April, which meant that it was only 7 vessels which were the subject of our claim for damages for non-performance, rather than multiple vessels spanning the whole duration of this COA. Now, one point which my learned friend has not addressed is why his clients decided that there was no merit in holding out for this very technical compliance with transmitting dollars when they were suffering no detriment at all by accepting RTI's offer to receive the same quantity of dollars that they would always have been entitled to, with RTI meeting all of the charges and costs associated with any exchange rate losses. And my submission is that the conduct of MUR in later accepting that proposal is a very clear indication of how reasonable commercial people would read this clause 36.3d, that reasonable endeavours do require a commercial response to this temporary friction in the banking system that Lord Justice Newey pointed out. Now, another important factor which needs to be stressed is that Lord Justice Males, with whom Lord Justice Newey agreed, is that the conclusion they reached did not involve any variation of MUR's contractual right to receive payment in dollars. If you go to the judgments at paragraph 54 in the Court of Appeal, Lord Justice Males says this: there was no question of it, that's MUR, being required to abandon or vary that right, referring to the
Could you just give me the paragraph again?
Yes, paragraph 54, my lord, which starts on at the bottom of the left-hand column on page 161 of the bundle.
Thank you.
He records, MUR, this is in the second sentence, MUR had a contractual right to rely on the force majeure clause as suspending its obligation to nominate vessels to perform the contract, but that right was subject to 36.3d. It also had a contractual right to receive payment of freight in US dollars. There was no question of it being required to abandon or vary that right. Rather, the question was whether accepting payment in euros would overcome the state of affairs resulting from the imposition of sanctions on Rusal. If it would...
Is that right? I mean, it's not performance in accordance with the contract.
But my lord, they can still sue for it. We're not requiring a variation. That solution does not require a variation or an abandonment of that right. It is simply stipulating what is required to give MUR the protection of force majeure in order to avoid a claim for damages for non-performance of their shipment obligations. Lord Justice Mills continues, if the question of accepting payment in euros would overcome the state of affairs resulting from the imposition of sanctions on Rusal, if it would, MUR's contractual right to receive payment in dollars would remain unaffected, and the only consequence would be that it would not be entitled to invoke force majeure as excusing it from its obligation to nominate vessels. And he stressed this point again at paragraph 57. If you pick it up at the very bottom of page 161, the arbitrator's finding in paragraph 50 of their award was that RTI's proposal would have presented no disadvantages to MUR and could have been accepted with no detriment to it. There was no doubt about the ability and willingness of RTI to make payment in euros and to bear any additional costs or exchange rate losses in converting the euros to dollars. Acceptance of RTI's proposal would have achieved precisely the same result as performance of the contractual obligation to pay in US dollars, namely the receipt in MUR's bank account of the right quantity of dollars at the right time. MUR's contractual right to payment in dollars remained, but MUR would have suffered no damage whatsoever as a result of RTI's breach consisting of payment in euros.
But yet you have a right to refuse to accept payment in anything other than US dollars. How is that not unaffected by this now?
Well, it's unaffected to this extent, my lord, because when someone is trying to set up a defence to continued performance by relying upon a first force majeure clause, they have to bring themselves clearly within the terms of that clause. And if there is a requirement to satisfy in those circumstances what reasonable endeavours to overcome the impediment requires. Now, they can choose whether or not to accept RTI's offer, but if they choose not to accept it, then they run the risk that the trier of fact will conclude that that refusal was unreasonable. And in circumstances where, as a matter of fact, it has been found that the solution proposed by RTI involved no detriment, no prejudice whatsoever to MUR, and that MUR's contractual right to sue for the very technical breach of transmitting euros, which is then converted automatically into dollars on receipt and paying all the costs, rather than transmitting dollars in the first instance, would give rise to no damages whatsoever. Now, that is a commercial approach which both the tribunal and the majority of the Court of Appeal favoured and considered would accord with what commercial parties negotiating this bargain would have agreed. They would not have thought that, presented with a solution which would have obviously overcome the temporary friction in the banking system, would enable the contract to be thrown into disarray and not performed solely because of that very technical infringement of the mode of transmission of the currency.
Leaving aside the reasonable endeavours provision, do you accept under this contract they would be entitled to refuse to accept payment in anything other than US dollars?
If it was other than a question of whether they can invoke force majeure clause, yes. Yes. And then it's a question of what loss would be suffered from that. If RTI had nevertheless gone ahead and paid euros and paid the losses and charges associated with the exchange rate conversion, what loss would MUR have suffered if it had sued on that breach of the contract?
Sorry, can I just take you back to the sentence of Lord Justice Mails
Yes.
you cited, and I think my Lord Hamlin asked you about. I mean, Lord Justice Mails says there was no question of it being required to abandon or vary that right. On the face of it, it does look as if one is being required to abandon or vary that right. Now, what did you say your answer to that was?
My answer to that
they could
is...
still sue on it, did you say?
Yes, they can sue on it. They can sue on it. I mean, that's what Lord Justice Mails says. At the end of paragraph 57, MUR's contractual right to payment in dollars remained, but MUR would have suffered no damage whatsoever as a result of RTI's breach, consisting of payment in euros. So this comes back to the central question. MUR are seeking to benefit from a force majeure clause in circumstances where they are under an express obligation under the specifically negotiated 36.3d, reasonable endeavours to overcome provision, to use reasonable endeavours to overcome the effects of the force majeure event, which consisted in the temporary delay that was likely to happen if US dollars were transferred. If they want...
So what you're submitting is that paragraph D might require a party to accept performance in breach of contract.
Yes, if it's reasonable. And that's a factual question which in these sorts of cases usually comes before experienced shipping arbitrators, but it comes before a trier of fact. And the submission was made before the arbitrators, well, we're entitled to insist on our contractual right to receive dollars. But the arbitrators saw through that and considered that there was no prejudice and no detriment to MUR whatsoever had they accepted RTI's eminently reasonable proposal. And that is why they came to the conclusion that they did in paragraph 50 of the award. Now, in terms of overall merits, all members of the Court of Appeal were agreed that MUR's position on the facts had no merit at all, and that it would plainly have been reasonable for MUR to have accepted RTI's offer to pay in euros on the no detriment basis that RTI had proposed. We've seen the passages in Lord Justice Mayles and Lord Justice Newey already, but Lord Justice Arnold, in paragraph 66, he says, on the facts of this case, MUR's position has no merit. And in 69, he says, plainly, it would have been reasonable for MUR to have accepted RTI's offer. And then in 74, he adds, I agree that RTI's offer would have solved the problem with no detriment to MUR. Now, the reason for Lord Justice Arnold's dissent was because he considered that if the parties to the COA intended clause 36.3d to extend to a requirement to accept non-contractual performance, clear express words were required and that there were none. He says this paragraph 74 at the end. And in coming to that conclusion, he attributes a very technical meaning to the word of overcome. He considers that providing a solution to the problem does not overcome the relevant event or state of affairs. That's in paragraph 73. And we would say that in that regard, he is in error. And that if you were to put this conundrum to a room full of commercial people and ask them whether, on the facts of this case, RTI's offer of a no-detriment solution to MUR, which involved MUR receiving the right quantity of dollars in its account at the right time, was something which constituted reasonable endeavours to overcome the problem, they would have said, of course, yes. Now, the question before this court, which we say is in contrast to the formulation in paragraph 6 of MUR's case, is accordingly whether the tribunal's conclusion of fact in their award in paragraph 50 and 51 and the reasoning of the majority of the Court of Appeal was infected by an error of law because, as MUR contends, absent an express permissive wording, an obligation on the affected party to use reasonable endeavours to overcome can never, and that means never, require a party to accept non-contractual performance, no matter...
An obligation, simply if you want to rely on this clause.
If you want to rely on the clause, you can never require of that party an acceptance of non-contractual performance, no matter how reasonable and detriment-free the offer of non-contractual performance may be, even of a currency obligation, where the currency offered is the commercial equivalent of the contractual currency. Now, the principle which has been formulated by the majority of the Court of Appeal is clear in our respectful submission. It accords with business common sense and will not give rise to uncertainty in its application. Well, the principle has been summarised pithily by the editor of Chitty, and perhaps I could ask you to take that out. It's in the core bundle, page 1395. One can pick it up under 27-066 on page 1394 under some general propositions. Although much will depend on the wording of the particular clause, it's possible to deduce from the authorities some general propositions in relation to the type of event that's likely to fall within the scope of the words force majeure, where they are used without further amplification in the contract itself. And then they go on, in such a case, the court is likely, and then there's a footnote, 305, it's important to recall that the issue is ultimately one of interpretation of the particular clause, and so it isn't inevitable that a court will reach such a conclusion in every case. Court is likely to conclude that the type of event that will fall within the scope of the clause is an event that was, 1, beyond the reasonable control of the parties, and so would not include an event caused by negligence, omission or default of one of the parties, 2, causative of the non-performance, and 3, could not have been overcome or avoided by the taking of reasonable steps. And then there is a reference in the footnote to Bullman, Channel Island ferries and B&S contracts and Ho Ching products. And then the editors go on to say, an obligation to take reasonable steps or to use reasonable endeavours in order to overcome the event may, in an appropriate case, require a party to accept a non-contractual performance. And that is footnoting the reference to the Court of Appeal's decision in this case, where the editors add this comment, where a practical approach was taken to the meaning of the word overcome, so that it encompassed a means of overcoming the event that did not consist of performance in strict accordance with the terms of the contract. However, it's important to note that on the facts of the case, the means chosen to overcome the event did not result in any detriment to the party to whom performance was owed, and it did lead ultimately to the performance to which that party was entitled.
So what is the principle?
So what we say is the principle,
The first full sentence on that page.
the first full sentence on that page, and a less decompressed version, which I have fashioned, tailored to our particular facts.
Sorry, which is the sentence?
An obligation to take reasonable steps or to use reasonable endeavours in order to overcome the event may, in the appropriate case, require a party to accept non-contractual performance.
Yes,
That's my understanding
yes,
of the position.
yes.
I think
What determines whether it's an appropriate case?
Yes, that's a factual inquiry which is inherent in many areas.
Well, is it that matters referred to in footnote 310, no detriment, and ultimately led to performance?
Yes. Now, my lord, what I'm going to do now is to give you a slightly less decompressed version of that principle, which is tailored to the facts of our case, and it is as follows. A force majeure event or state of affairs, which is outside the immediate control of a party, and which is caused by one or more
You go a bit slower.
Yes, of course,
Next.
Outside the immediate control.
of that party or of the affected party, and which is caused by one or more of any rules or regulations of governments,
Sorry, by one or more of any clause.
of any rules or regulations of governments, or interference, or acts, or directions of governments, or restrictions on monetary transfers and exchanges, which prevents or delays the loading of the cargo at the loading port,
Sorry, which prevents.
or delays the loading of the cargo at the loading port and or the discharge of the cargo at the discharging port, comma, can be overcome by reasonable endeavours from the party affected, where, on the facts, it is reasonable for that party to accept an offer of non-contractual performance.
Sorry, where on the facts?
It is reasonable for that party to accept an offer of non-contractual performance in respect of the currency of a payment obligation. Full stop.
That sounds like your broad submission, is it?
My Lord, it certainly covers the facts of this case. It's tailored very much to the facts of this
Very
case.
much so.
And I haven't quite finished the principle because it continues. It will be reasonable to accept such an offer where, on the facts, acceptance of such offer involves no detriment or other prejudice to the affected party and achieves the same result as performance of the contractual obligation. Now that's my synthesis of what Lord Justice Males has said in paragraphs 57 to 59, being the principle with which Lord Justice Newey also agreed in paragraph 78.
That last sentence you're accepting is a requirement of has to be reasonable.
Yes, because that is what the Court of Appeal have decided.
So you accept that your broad submission is qualified to that extent?
Yes. Obviously, for the purposes of this appeal, I don't need to go further than the facts of this case. And on the facts of this case, there was a no detriment, no prejudice solution that was found by RTI, which the tribunal have held should have been accepted. So I don't need to go further than that for the purpose of upholding the decision of the tribunal. Now, it may be that other cases with slightly different wordings in a different context involving different obligations may yield of a different conclusion. But that's not the concern of my clients in this appeal. And the fact that the court has approved in the Court of Appeal by a majority a solution which is an obviously commercial solution, one which would commend itself to businessmen and women, is something which will affect the parties' approaches going forward and those of others in the same industry as to whether they want to amend their clause or whether they want to rely upon more explicit wording. But that's not for today. For today, what we're addressing is whether the principle is a coherent one that the Court of Appeal have formulated, and I submit that it is. We also need to consider whether it is opening the floodgates, and I submit that it is not. It's very tightly bound by the fact setting in which that principle arose. And as we will see when we come to look at the authorities mentioned in paragraph 66 of RTI's written case, it has been favourably received. The only query which my learned friend has majored on is an observation by Professor Peel in an article in the Lloyd's Maritime Law Quarterly, which was made before this case had the subject of permission to appeal granted, and suggested that the case ought to be considered on appeal because of potential ramifications. But my position is that if you construe the purport of the majority's decision, which is solidly founded in principles of contractual construction with which all of this court's members are very familiar with, it is true to those principles. And in particular, it is true to the principle that where you have two rival interpretations, which are urged, the court is entitled to prefer the interpretation which accords with business common sense. And given...
I'm not, I mean, just going back, I think, to what Lord Henry said, your second sentence, it will be reasonable to accept such an offer.
Yes.
Where it involves no detriment. I mean,
Yes.
Is that, from a commercial person's point of view, an essential ingredient of this test of reasonableness? I mean, put it this way, if you were to say to commercial people, you must accept an alternative performance, even if it involves some detriment or prejudice to you, you might very well get a rejection by the commercial person that was commercially sensible.
Yes.
So I want to be clear what your principle is, what you're urging on us.
My principle is that it will be reasonable for a party to accept an offer of non-contractual performance in respect of a currency of payment obligation where it leads to no detriment or other prejudice.
Yes, but that's very... I mean, are you saying that this principle only applies where we're talking about the currency of payment, or does it have a broader application to other terms?
I say that it has an application to the currency obligation that we are concerned with here.
But to no other term?
It may be for other cases to decide whether it has a broader application. I don't need to advocate that in this court.
Well, is that right? I mean, are we just concerned here to decide on very specific limits that you're suggesting? If it was the case that one could think of analogous facts where the principle starts to waver or not to be so, on the way you're putting it, not so obvious, such as what's meant by detriment, how do you prove detriment, etc. Don't we have to take that into account? I mean, we're not here just to decide this case for your client and the clients on the other side. We're obviously having to lay down more general principles of law.
My Lord, I fully take that on board, but in terms of the arguments that are being pressed by MUR, they suggest that the limits of the principle are untested and untried. And it may be that that is so, because this is the first case which has actually come under scrutiny by this court. But in terms of detriment and prejudice, there's been no attempt to challenge the fact that there's no detriment or prejudice here. And indeed, one can see from the findings that were made by the tribunal that because MUR was insisting that it was entitled to suspend performance because it didn't have the right number of dollars in its account at the right time, a solution which gives it the right amount of dollars in its account at the right time obviously eliminates all the negative consequences of the event which they claim to be a force majeure event. So that is the specific fact context that we are concerned with here. Now, it may be that on different facts we are looking at matters which are not solely governing the currency of a payment obligation, but currency of payment obligation is something which is topical, because where one has a background of sanctions, that background is likely in the future to give rise to potential friction in the banking system with inability to transfer particular currencies, where one has a party whose parent may be on a sanctions list. So it's not going to be solely of relevance to this case if you limit it to currency.
But I mean, aren't you creating a problem for yourself here? Because what you're seeking to say is that this clause should be read as applying, as I understand your argument, only to variations in contractual performance of the currency of payment.
Only where
I mean, if that were intended to be the very limited extent in which non-contractual performance had to be accepted, surely it would be spelt out.
My Lord, I haven't made it clear, and I apologise for that. My formulation of the principle, which was the expanded version, was targeted to the particular facts
Yeah, but
of
we're
my
looking
case.
for, as my Lord Barrow says, the principle which is to be applied in determining whether non-contractual performance is required to be agreed to by the party affected.
Yes. Yes. Well, the principle that is set out in the extract from Chitty, an obligation to take reasonable steps or to use reasonable endeavours in order to overcome the event, may, in an appropriate case, require a party to accept a non-contractual performance. That principle is obviously
with respect,
capable.
That's not a principle at all, because it leaves completely unresolved what an appropriate case is.
But an appropriate case will be one where, as a matter of fact, it is held that reasonable endeavours to overcome require that conduct.
So the parties agree that whether they should be required to accept non-contractual performance is to be determined by a third party, either an expert or an arbitral tribunal or something
Well,
like that.
I mean, the tribunal that was agreed upon here was an expert LMAA tribunal, and reasonable endeavours to overcome, as my learned friend has urged, is a phrase which is not unusual and is indeed, he says, to be implied even where it is not expressed. So the concept of
That's your
reasonable...
broad proposition.
Yes.
I understand you accept the qualifications which the majority of the Court of Appeal made as to the circumstances in which it may be appropriate.
Yes, I do. I do. And we also...
The slight problem with relying on Chitty is that that's an attempt to describe, in pithy terms, admittedly, what the Court of Appeal laid down. The question we've got to decide is not what we've got to decide, is Chitty correct in its description? That is the Court of Appeal correct? So it's, in a sense, all I'm saying is it doesn't take you any further than the majority of the Court of Appeal. To cite Chitty, as I would see it, Chitty is just trying to describe what has happened so far. I don't think you can say, oh, this represents Professor McKendrick's approval of the decision in the Court of Appeal. He's just describing what the Court of Appeal has laid down, as I would say it.
Yes. I mean, there are other academic texts and indeed a decision of Mr. Justice Foxton in the Gravelaw case, which I will come on to, which do offer broad endorsement of the approach of the Court of Appeal. But the reason for showing you that the pithy statement in Chitty was in response to my Lord Hamden's question, well, what is the principle?
Yes.
And then I expanded the principle in the way that I endeavoured to do, which is very much linked to the facts of this case, which concerns a currency obligation. Now, it may be that the court will want to take the opportunity to expand the ambit of the application of that principle to non-currency obligations and to other force majeure events in subparagraph C. But for the purposes of this appeal and my client's position, we are obviously concerned with the currency obligation, and that is not something which is going to be necessarily one-off because of the implications of sanctions on paying currency in US dollars direct to counterparties in the current regime that we have with sanctions. We submit that MUR's argument, if accepted by this court, would have far-reaching adverse consequences. It would enable any party to cling to its contractual right to receive payment in a particular currency in order to suspend performance under a contract where there is a force majeure event delaying or preventing payment in the contractual currency, even where payment can be made in another currency with no detriment to the receiving party because reasonable endeavours to overcome cannot extend to accepting a non-contractual currency. That is an uncommercial result, I would respectfully suggest, and does not accord with what I will go on to address you on as the correct principles of interpretation. I think this is my 10th introductory point, as the tribunal has found, this is the award paragraph 50 and paragraph 24 of the Statement of Facts, MUR did in fact accept euros from RTI in payment without rejecting them. We say this is consistent with and indicative of what commercial parties would expect to be the result of a clause obliging MUR to use reasonable endeavours to overcome.
This was later on in April.
Yes, it was.
Thank you.
It was, and there was no material change in the legal regime. So it's consistent with and indicative of what commercial parties would expect to be the result of a clause obliging MUR to use reasonable endeavours to overcome potential delays in transmission of dollars. MUR's construction denudes clause 36.3d of any real content and meaning in the context of restrictions on currency. The construction of that clause which MUR favours would require, in effect, the court to hold either that the words reasonable endeavours to overcome bear a special meaning, such that as a matter of law it can never be reasonable to expect a party to accept non-contractual performance, however reasonable or commercially equivalent that alternative performance might be, or that clause 36.3d has to be read as subject to an implied exception in respect of any form of non-contractual performance, unless the parties expressly stipulate that reasonable endeavours to overcome can include accepting offers of non-contractual performance. Now, there is no authoritative academic text or case law which supports MUR.
Or you?
Well, I will get on to BNS and Green, because we say that that is consistent with the approach that we adopt. There's no support for MUR's case that reasonable endeavours to overcome a force majeure event or state of affairs cannot, as a matter of law, include non-contractual performance. Now, RTI's case is that, as a matter of construction, that phrase that we are focusing on in clause 36.3d bears its ordinary and natural meaning, and there's no warrant for restricting that meaning or implying any term that restricts that ordinary and natural meaning. Accordingly, because the question of whether taking a particular course of action constitutes reasonable endeavours to overcome is one of fact to be arrived at upon an evaluation of all the evidence, which is a task tribunals in shipping matters in particular are very used to doing. MUR's appeal.
Accepting the Court of Appeal's qualifications, you are accepting a qualification to what you say is its ordinary and natural meaning. It's not just a question of reasonableness.
Well, but you have to look at whether the solution which is being posed satisfies the terms of reasonable endeavours to overcome. The tribunal have concluded, as a matter of fact, that it does, because of the no prejudice, no detriment. And they have construed, the Court of Appeal has construed reasonable endeavours to overcome in a way which preserves MUR's contractual right to receive contractual performance and sue upon it if it so chooses, but deprives it of the right to invoke force majeure if it does not accept a commercially equivalent performance to that which it is entitled to under the contract. So those were my introductory comments. I'm going to address the issues in the following order. Firstly, principles of construction that apply to ascertaining the meaning of reasonable endeavours to overcome in clause 36.3d of this contract, and then to see how the approach of the Court of Appeal is matched with that approach. Secondly, I'm going to look at the Bullman and Vancouver strikes cases that my learned friend has dealt with and continues to rely upon. Thirdly, I'm going to deal with the Gilbert-Ash principle. Fourthly, I'm going to say something about the judgment of Mr. Justice Jacobs. Fifthly, I'm then going to look at principles of mitigation and frustration and whether assistance can be gained from those principles. And with your leave, my lords, in that connection, I was going to ask my learned junior to address you on the Suez cases as part of that topic. He'll be about 20 minutes.
Sir.
My sixth issue is policy considerations, and I'll obviously be addressing in the context of that issues of certainty. And then finally, wrapping up with why MUR's appeal should be dismissed. So, my lord, I'm reminded that we're coming up to 3:30. Would you like me to start, or would a break be convenient now?
Well, you're planning a break this afternoon, yes. Well, it seems to be sensible that we take the break at this point.
Thank you.
Thank you very much.
So, my lords, turning then to principles of construction, we submit that the normal principles of construction and interpretation of commercial contracts will apply. So we have the guidance of the Supreme Court in Arnold and Bennett, with which you're very familiar, and Woods and Capita. And those cases make plain the court's task is to consider what a reasonable person who had all the background knowledge that would reasonably have been available to the parties at the time of contracting would have understood the parties to mean in clause 36.3d when using that phrase, reasonable endeavours to overcome a force majeure event or state of affairs. And if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. Now, a convenient synthesis of what the exercise of interpretation involves is set out in the Ocean Neptune case, and indeed mirrors the principles in Woods and Capita. And I might just refer you to that. It's at page 1550 of the bundle and is set out in Shitty, current edition, at paragraph 16053 by Mr. Justice Popplewell, as he then was.
Do we have,
Is this
do we have
add
a
to
reference to Chitty?
Wood and Capita?
I'm sorry, it's 1550.
Does it add or differ from Wood and Capita at all?
It doesn't. It just breaks down the test into objective nature of the assessment, factual matrix or available background, meaning of language used by the parties, need to have regard to the contract as a whole, significance of the nature, formality and quality of the drafting, what is to be done when there are two possible meanings of the disputed clause, the unitary and iterative nature of the process, and striking the balance between the various potentially conflicting principles. It's there because it's a useful summary, and I leave it to the court to look at it again if they wish.
Sorry, what are you asking us to look at? 1550, that's an extract from...
It's an extract from Chitty, but it quotes from the Ocean Neptune, the relevant passage, which deals with a summary of the applicable principles, which in fact has been approved in the subsequent cases.
So, sorry, where do I find that?
If you're looking at 1550, it should be part of paragraph 16053. I hope that...
Oh, sorry, right, thank you very much, yeah.
And we've got there the passage that I was referring to. Now, we've set out in our written case at paragraphs 16 and 17 specific principles which have been developed in relation to force majeure clauses as supported by textbooks and case law, and I can summarise those. The first is that such clauses are generally to be construed narrowly against the party seeking to rely on the force majeure clause, in this case MUR. That's Professor Peel. The second principle is that clear words are required to shield a party, in this case MUR, from what would otherwise be a liability in damages for non-performance. That's derived from Chitty, which is at page 1395 of the bundle, at paragraph 27067, which under the rubric approach to interpretation says this: the general principles applicable to the interpretation of contract terms are also applicable to force majeure clauses. While cases can be found in which the courts have applied a strict approach to the interpretation of force majeure clauses, a modern court is more likely to apply the same approach as that which it would take to the interpretation of any other term of the contract, at least where the parties to the contract are roughly of equal bargaining power and have access to legal advice. That said, the courts are likely to insist on the use of clear words, given that the function of the clause is generally to shield a party from that which would otherwise be a liability in damages in respect of its non-performance. So that makes clear that the burden is on MUR to show clear words that support its construction. The burden is not on my client to show express words permitting non-contractual performance. The third principle is that ambiguity is generally to be resolved against the party seeking to rely on the force majeure clause. Now that emerges from the crude sky in the Court of Appeal. My learned friend has suggested that that's no longer a modern approach. However, Peel, at page 1422 of his textbook on contractual provisions for on force majeure and frustration, in a chapter dealing with provisions for non-frustrating events, refers to that case in footnote 227, and it's under the rubric construction in general, a tendency toward narrow construction. Although there may be a tendency to construe a clause of the present kind narrowly against the party seeking to rely on it, there is no rule of law to this effect, and then it gives two contrasting cases.
What's the page?
Pages 1422, 1423. And the fourth principle is that the burden of proof is on the party seeking to rely upon the force majeure clause to show that all the ingredients are satisfied. Again, I'll use Chitty to illustrate that. Page 1403 of the bundle, at paragraph 27082, under burden of proof, it is for a party relying upon a force majeure clause to prove the facts bringing the case within the clause, ... Depending on the terms of the contract, it may also be required to prove ... But there were no reasonable steps that it could have taken to avoid or mitigate the event or its consequences. And then if one goes down to the end of that paragraph, it has been held that there's no justification for limiting the ordinary meaning of words in a force majeure clause to events or states of fact not in existence at the date of the contract, or to those which are unpredictable at the time it was made. In short, it's necessary to have regard to the wording of the particular clause in dispute. Then the fifth principle is that there is no justification for supplementing the ordinary meaning of words in a force majeure clause. And again, the relevant authority is the passage that I've just read you from Chitty. And finally, and importantly, in each case, the question is one of interpretation of the particular clause, and care must be taken to avoid drawing conclusions of apparently a universal application from a case which turns on the wording agreed by parties in the context of a particular force majeure clause. We find that principle set out in Chitty 1399 of the bundle, at paragraph 27073.
Sorry, could I ask you to repeat the fifth proposition?
The fifth proposition is that there's no justification for supplementing the ordinary meaning of words in a force majeure clause with additional rules for their application. And the example given by Chitty in the passage we looked at page 1404 is a rule that would limit the application of the clause to events not in existence at the date of the contract.
Yes.
Or those that were unpredictable.
Thank you very much.
And then my final proposition is stressing the need to avoid drawing conclusions of universal application from cases where the wording is different and the context is different. That's 1399, and one can find that towards the end of that paragraph with the sentence beginning in each case. The question is one of interpretation.
Thank you.
But I'm right in saying that this is a standard reasonable endeavours clause.
There are many reasonable endeavours clauses that one encounters in practice. Not all of them use the word overcome. Some of them may use different formulations. I think the one that is in Cedril and Tullow uses much broader language, a number of words which are synonymous with overcome. But it does depend on the precise words that one encounters. And again, the context in which they have to be construed.
Well, I understand the context, but I think what I'm asking you is, are you not accepting that this is a standard reasonable endeavours clause?
It's not one that is uniformly found in all cases. We know that the parties here specifically introduced it into the recap. I've not checked to see whether that particular wording features exactly in any of the other force majeure cases that we've been looking at. So I'm not able to say with any degree of confidence that it's standard. I would respectfully submit that nothing is to be gained by trying to fit it within a straitjacket of another case concerning a clause that may appear similar, but in fact the conclusions on construction may not have no bearing on the points that we are concerned with today.
Are you suggesting there's anything in the language of this clause that differentiates it from many force majeure clauses which either explicitly or implicitly have a reasonable endeavours?
Yes. What I can say is that I've not seen any reasonable endeavours clause have an express stipulation that it includes non-contractual performance. It's not something which I've ever seen before, and what is being suggested by MUR is novel.
No, but the Court of Appeal laid great stress on the word overcome.
Yes.
And Mr. Eden points out that that's really no different to words used in many force majeure clauses or words which would be implied into most force majeure clauses.
What we
disagree with that.
What we say in relation to that is that my learned friend is supporting Lord Justice Arnold's analysis, and he adopts a very technical and we would say uncommercial approach to the interpretation of overcome on the facts of this case by saying it doesn't mean the same as solve the problem. To overcome the problem does not mean to solve the problem. And you'll remember that in the written case, there's the example given of scaling one of the peaks of Everest, and you don't say you've overcome that if you sort of go by a different route. But
that's not my question. My question is whether there's anything special about the word overcome as opposed to other terms you might get, like take all reasonable steps or whatever it may be.
My Lord, I'm not able to say that there's something unique about this particular clause, and indeed when you look at synonyms for overcome in dictionary definitions, which we've done in RTI's case, they all suggest a broad number of synonyms which it can be interchanged with, and I think my learned friend also has suggested other synonyms that it can be exchanged with just as easily. So we would suggest that suggests a very broad and commercial construction should be adopted when looking at that word.
And do you say that it's not clear-cut whether, let's assume that there was no express reasonable endeavours clause here, what is your response to the submission, well, it would have been implied in any event?
Well, my Lord, it may be implied that someone's required to act reasonably, but query whether the word overcome would have been the subject of focused attention if it was an implied provision rather than an express provision. What the focus of the inquiry is, well, what is the effective cause of the inability to perform? Is it the event or state of affairs created by the friction in the banking system on our facts, or is it an unreasonable response by the parties seeking to rely on force majeure to that problem? And the fact that one suggests from MUR's analysis that you don't need to look at the words, but yet there is an impediment to looking at non-contractual options is rather in tension.
So it's critical to your submission that the word overcome is there, is it?
Well, we have to deal with overcome because it is part of the clause, and indeed the Court of Appeal had raised during the course of argument the significance that they attached to the word overcome when counsel on neither side had previously done so, and indeed the way in which the question of law had been formulated as it proceeded to both Mr. Justice Jacobs and then to the Court of Appeal assumed that we were focusing on the meaning of reasonable endeavours and that overcome was sub silentio assumed as being the product of what reasonable endeavours would result in. So it's not a question of change of case, it's a question of the Court of Appeal rightly, in my respectful submission, considering that this word had significance and looking at whether overcome has got a sense in meaning which would either permit or deny validity to the solution that RTI proposed, in which the tribunal found MUR should have accepted, namely accepting in its bank account dollars when those euros that were sent would have been automatically converted into dollars. That's the finding of the tribunal. Now, the last point that I made on the principles of interpretation, i.e. that you've got to look at each clause with care, is important, and it does expose the fallacy of my learned friend's approach, because they would seek to persuade you to deduce a principle of apparently universal application, namely reasonable endeavours to overcome can never, absent express stipulation, include accepting non-contractual performance, even on a no-detriment basis, from the Bullman and Vancouver strikes cases, which are very different on their facts and concern interpretation of strikes exception clauses, not a force majeure clause. To similar effect, and I won't ask you to turn it up, page 1392, Chitty, paragraph 27062, makes the same point about not seeking to deduce propositions from other cases. And indeed, Mr. Justice Bacardi, in the flag-bearer case of my learned friend's submissions, Le Beaupin and Crispin, also made the same point, that each case has got to be construed with close attention to the words which precede or follow it, and with due regard to the nature and terms of the contract. Now, we do take fundamental issue with MUR's approach, which continues to press conclusions allegedly drawn from Bullman and Vancouver strikes, rather than an analysis of the words used in the force majeure clause. And it's notable that Lord Justice Newey, in paragraph 78 of his judgment, observed that the approach of MUR had been to eschew close textual analysis. But we say that far from being unlikely to assist, the rules of contractual construction are central. The correct approach is to construe the clause, both its text and its context, rather than rationalising from other cases with different words and different contexts. Now, Professor Peel, in his book, at paragraph 12045, and the page in the bundle is 1424, which perhaps I could just ask you to turn up, has a discussion under the section obligation to use reasonable endeavours. And he says, this is at the bottom of page 1424, what is required by way of reasonable endeavours is a further question of construction and dependent on the context in which the obligation arises. According to Mr. Justice Tier in the Seadrill case, in the context of a force majeure clause, quote, the mere fact that a step is contrary to a party's commercial interests is insufficient to show that it has exercised its reasonable endeavours. since in such context the party cannot ignore the commercial interests of the other party in the force majeure being avoided or circumvented. And then he goes on 5 lines down, how far a party is required to go in this respect may not always be certain, as is evident from the contrasting examples referred to by Mr. Justice Tier. The mere fact that a step to avoid or circumvent a moratorium would or may be unprofitable wouldn't necessarily lead to it being regarded as unreasonable. By contrast, were it known that a well was dry, there would be no purpose in completing it, and it would be outside the contemplation of the parties that it should be completed in those circumstances. Reasonable endeavours would not require completion. Now, that's quite an important passage because it shows that there is obviously going to be a factual inquiry in any given case as to what reasonable endeavours will require. And that does not mean that it's uncertain or, for that reason, a bad principle. It is simply a function of looking at what the clause requires you to do, have reasonable endeavours to overcome or deal with or avoid the negative impacts of this event being exercised by the party seeking to rely upon force majeure. The fact that the Seadrill case considered that a party was required to act outside of its commercial interests in order to take the benefit of the clause is also highly relevant. If one takes this example, one definitely finds a tension which exposes the flaw in my learned friend's case. It's an absurd anomaly. And as we say in paragraph 47 of our case, it's hard to see why clause 36.3d should preclude a force majeure event where a party is able to overcome an impediment by taking expensive or inconvenient yet reasonable steps. That's based on the Seadrill case, but not where that party is able to take entirely convenient and expense-free steps that happen to involve the acceptance of non-contractual performance. Now, that consideration shows you that there is no reason to draw such an artificial bright line as my learned friend has sought to do. Yes, you have to look at the facts. Yes, you have to assess what is reasonable. Commercial arbitrators and first instance judges are very able to do this, and it is not going to be in the interests of certainty to lay down a bright line that can lead to very uncommercial results. And again, the discussion in Peel contains no formulation of a general principle such as that advocated by MUR, and which found favour with Mr. Justice Jacobs, that excludes from the scope of reasonable endeavours to overcome any obligation to accept non-contractual performance, where it would on the facts be reasonable to accept it, and it would solve the impediment to loading and discharge. Now, I was going to come on to B&S contracts.
Are you suggesting that Seadrill exemplifies a case where there was, one had to, in order to comply with one's obligation to use reasonable endeavours, do something that was not required by the contract?
No, the way in which the force majeure provision was construed was to require the affected party invoking force majeure to act reasonably, which can include acting in a way which is contrary to its commercial interests. It all depends on the facts. We can look at that case in more detail when I get on my feet tomorrow, my Lord, if that would be convenient. Yes. My Lord, I also wanted to show you B&S contracts and green. We've dealt with this case in paragraphs 35 to 39 of our case.
Are you dealing with this shortly?
No.
No,
It may be that I should deal with it tomorrow.
That's a convenient place to adjourn, I think.
Thank you.
Thank you. We'll resume tomorrow morning.
Thank you.